There's a new real estate law in Missouri that just passed. And if you're working in probate, estate planning, or assisted living, or if you've been named as an executor or personal representative of an estate, I think this is genuinely important for you to understand. My name is Terry Peterson. I'm a licensed real estate agent and investor in St. Louis, and my practice is almost entirely focused on estate and probate real estate, helping families, executors, trustees, and the attorneys and advisors who work with them navigate the sale of property during some of life's most difficult transitions. Today, I want to walk you through Senate Bill 973, what it does, why it was needed, and what it means in practical terms for the people you work with every day. Before we dive into this material, I want you to know that I talk with people just like you every day that are dealing with estate and probate real estate. Please give me a call. I'm here to help you as well. Now, let's start with the problem. For years, real estate wholesaling has existed in a legal gray area in Missouri. Here's how it typically works. A wholesaler, someone who markets themselves as a cash buyer or a we buy houses type investor, approaches a homeowner, makes an offer, gets them to sign a purchase contract, and then, instead of actually buying the property, finds another buyer and sells that contract for a fee, sometimes thousands of dollars. The actual sale happens between the end buyer and the original seller. The wholesaler collects their spread and walks away. Now, there are legitimate investors who use assignment of contract as part of how they do business, and some of them provide genuine value, especially in situations where a property needs significant work or a quick sale matters. I want to be fair about that. If an investor is financially capable of closing the deal, has done their due diligence, and is transparent with the seller, that's a different situation. But the law was clearly designed to address a more problematic version of this. Situations where sellers end up locked into contracts with someone who had no real ability or intention to close. That scenario has shown up with distressed sellers, and it's also shown up in estate and probate transactions where an executor or a personal representative may be unfamiliar with real estate and eager to simply settle the estate. The core issue isn't assignment of contracts. The core issue is transparency. The seller often didn't know the contract might be shopped to other buyers. They didn't know their price might be a steep discount from what the estate could actually net. That's exactly what this law is trying to fix. So what does SB 973 do about this? The law doesn't ban wholesaling in Missouri, and I actually agree with that approach. Outright banning it would go too far. What the law does instead is force transparency. Here are the key provisions. First, before entering into any contract on a residential property of one to four unit properties, a wholesaler must provide the seller with a separate written disclosure at least 14 days before the contract is signed. This isn't buried in the contract. It's a standalone document. That disclosure must specifically tell the seller four things. One, that the buyer is acting as a wholesaler. Two, that the contract may be assigned to another buyer for profit. Three, that the wholesaler may never actually take title to the property. And four, that the agreed upon price may be below market value. Second, the statute gives the seller the right to cancel the contract before closing if the disclosure was not properly provided. That's the language of the law itself. Violation can become claims under the Missouri Merchandising Practices Act, which opens the door to private lawsuits and Attorney General enforcement. It gives this law real teeth. And finally, the bill also includes new protections around sale-leaseback arrangements, where a homeowner sells their home and then stays on as a tenant. This has become more common with certain investor models, and it can be particularly dangerous for elderly or financially distressed homeowners who may not fully understand that they are giving up ownership of their home. New disclosure requirements apply there as well. What this means if you're an attorney. Let me speak directly for a moment to estate attorneys and probate attorneys, because I think this law is especially relevant to your practice. When you're helping a family administer an estate that includes real property, your client, the executor or personal representative, is often in a difficult position. They're dealing with grief, time pressure, unfamiliar processes, and a fiduciary duty that they may not fully understand the scope of. In that environment, an offer that sounds simple and fast can be very appealing, which is exactly the kind of situation this law was designed to bring more transparency to. Under SB 973, if a wholesaler approaches the estate and fails to provide the required 14-day written disclosure, the statute gives the seller the right to cancel before closing. Whether that applies in a given situation and what it means for a specific transaction is a legal question, but knowing to look for that disclosure is a useful first step. I'd encourage you to add a simple review step to your estate administration process when your client receives any unsolicited offer on estate real property. Ask to see the required disclosure. If it's missing, that's a meaningful flag worth examining with counsel. And if you're not sure whether an offer is coming from a wholesaler or a direct buyer, call me. That's the kind of thing I can help you evaluate quickly. Now, what does this mean if you are working in an assisted living facility? For those of you in assisted living marketing or senior care coordination, I want to acknowledge something. You are often the first professional relationship a family has when a parent transitions into memory care or assisted living. That means you frequently hear about financial pressures, the family trying to figure out how to fund care, sometimes involving the sale of a home. In those situations, we buy houses type offers can sound very appealing. Fast closing, no repairs, no showings, no hassle. And sometimes, depending on the property and the situation, that may genuinely be the right path. But families deserve to understand what they're agreeing to. This new law gives them at least a baseline of protection, and knowing it exists lets you play a more informed role in guiding families towards the right resources, including making sure they're working with a real estate professional who understands estate and senior transitions, not just someone who showed up with a contract. What this means if you're an executor or a personal representative. And if you are an executor or a personal representative, someone who has been named to administer a loved one's estate, I want to speak to you directly for a moment. You have a fiduciary duty. That means you are legally obligated to act in the best financial interest of the estate and the beneficiaries. If you accept a below market offer without exploring what the property could actually net, and if that decision later gets scrutinized by a beneficiary or court, it could create real problems for you. SB 973 doesn't make your job harder. It actually makes it a little easier to know when something isn't just right. If someone approaches you with an offer and can't show you a written wholesale disclosure, that's a signal to pause. And you should know selling estate property doesn't have to be complicated or slow. There are ways to price it right, prepare it appropriately, and sell it efficiently while still fulfilling your fiduciary duty. That's exactly what I help executors do. Missouri Senate Bill 973, assuming it is signed by the governor and becomes law, the effective date is August 28th of 2026. It's not a dramatic overhaul of the real estate market. What it is a transparency law, and I think that's the right framing. Most of the wholesaling disclosure requirements are reasonable. Seller deserves to know when someone intends to assign a contract for profit and may never actually close themselves. That's not an unreasonable thing to ask. I think it's good for consumers, good for legitimate investors, and good for the real estate profession overall. If you have questions about a specific property, a transaction you've seen, or how this law might apply to a situation you're navigating, I'd generally love to talk through it with you. I'm Terry Peterson with St. Louis Family Resources, powered by More Realtors. My phone, email, website, and social media links and numerous resources are in the description below. Thank you for taking the time to watch. I hope this was helpful. Take care.